दोस्तों, मैं रोहित कुमार एबनीशो की ओर से आपका स्वागत करता हूं।
Today we will start our discussion on pure theory of law. This also falls within the school of analytical positivism, and this is the last jurist of that school that we are going to discuss today. Hans Kelson, Hanskelson, Hans Kelson, 1881 to 1973, his time period, 1881 to 1973. Hans Kelson was another jurist who has the credit of reviving the original analytical legal thought in 20th century, and he did it through his pure theory of law. So let me give you his brief introduction. Hans Kelson was born at Prague it was in Austria at that time. He was born in 1881 and he worked as a professor of law in the Vienna University. He also served as a judge of the Supreme Constitutional Court of Austria for 10 years during 1920 to 1930, and when it looked that Second World War is around, he shifted from Austria to England, and from there he went to United States of America. There he worked as a professor of law in several American universities, and he authored many books in USA. He was an emeritus professor of political science in the California University, where he expounded his pure theory of law. And pure theory of law is considered to be Kelson's unique contribution to legal theory. So we'll start with Kelson's pure theory of science of law, pure theory of science of law. Like his predecessors, Kelson also did not favor widening the scope of jurisprudence by correlating it with all other social sciences. And he rigorously insisted on separation of law from politics. He said that law should be separated from politics. He believed that law also should be separated from sociology. He said that law should be separated from metaphysics and all other extra-legal disciplines. So he believed that extra-legal disciplines like sociology, politics, metaphysics, history, ethics, morality, justice, these things have nothing to do with law. And very often it was said that Kelson's pure theory of law tried to rescue jurisprudence from vague mysticisms, and thus it was in a way a revival of John Austin's 19th century analytical jurisprudence. क्योंकि आप लॉ को सभी चीजों से अलग करने की कोशिश करके थ्योरी देने की कोशिश कर रहे हैं, तो आप ये मानते हैं कि हम कानून को वेग मिस्टिसिज्म से दूर हटा रहे हैं. And in a way that was a revival of John Austin's theory. Like John Austin, Kelson also divested morality, ideals or ethical element from law, and he also wished to create a pure science of law which is devoid of all moral and sociological considerations. तो लॉ की थ्योरी जो है वो प्योर होनी चाहिए, इसका आइडियल से सोशियोलॉजी से कोई रिलेशन नहीं होना चाहिए, बिकॉज दीज आर extra legal consideration. But he also rejected John Austin's definition of law as command of the sovereign. He said that law cannot be a command of a sovereign because it introduces subjective considerations, whereas he believed that law to be an objective consideration, legal theory to be an objective consideration. And he also discarded the notion of justice as an essential element of law. He said that justice cannot be an essential element of law. Justice का law से क्या लेना देना है? Because many laws they may not be just, but still they may continue as law. कई law ऐसे होते हैं, they are not just, they are unjust, but they still are law and they continue to be law. So when he said that legal theory should be pure theory of law and law in itself is a science, he distinguishes legal science from natural science. तो सबसे पहले साइंस क्या होता है, साइंस की डेफिनेशन कैसे दी है उन्होंने. प्लीज ट्राई टू नोट इट डाउन. व्हाट इज साइंस फॉर हिम? साइंस इज अ सिस्टम, प्लीज नोट इट डाउन. साइंस इज अ सिस्टम ऑफ नॉलेज और अ टोटलिटी ऑफ कॉग्निशंस सिस्टमैटिकली अरेंज्ड अकॉर्डिंग टू लॉजिकल प्रिंसिपल्स. That is the definition of science given by Hans Kelson. So when he talks about his basic norm, that is Grundnorm. Grundnorm is analogous to John Austin's concept of sovereign. And without that Grundnorm, law cannot be obligatory or cannot be binding on the people. तो जैसे आपने देखा कि जब तक sovereign ने sanction के थ्रू लॉ को इम्प्लीमेंट नहीं किया तो लॉ बाइंडिंग नहीं हो सकता है। जैसे कल हम एचएलए हार्ट के भी थ्योरी में देख रहे थे कि विदाउट रूल ऑफ रिकॉग्निशन लॉ cannot be binding on the society. Similarly, without the grand norm, that is basic norm, law cannot have a binding effect. Thus, Kelson's pure theory of law is a theory of positive law which is based on normative order. So, theory of law जो Kelson ने दी है, that is based on normative order which eliminates all extra legal considerations, all non-legal elements from the law. He believed that a theory of law should be uniform throughout the world. Theory of law should be uniform throughout the world. So Kelson's theory of pure science of law, which is also known as theory of interpretation. This theory is also known as theory of interpretation. It is a reaction against vicious ideologies which was corrupting the legal theory of that time and the jurisprudence of a totalitarian state. उसके against भी एक reaction था. It was a reaction against vicious theories that was corrupting the jurisprudence, and also it was a reaction against the theories of totalitarian states. And that is why he nomenclatured his theory as a pure theory of law or pure science of law, because science to be called rational. Science is what? Science is a rational thing, and it must stand in a twofold relation to its object. So science is always rational and therefore it must stand in a twofold relation to its object. That means first, science determines the conceptions of the object and it establishes its reality. Science is the only thing which can establish its reality. Science is the only thing which determines the conceptions of the object. And when science determines its conceptions of the object, it is a theoretical element. Whereas when it establishes its reality, it is practical aspect of it. Kelson claims that his pure theory of law is applicable to all places and at all times, something that was claimed by natural law theorists also. This theory, he says, is applicable to all places at all time. And legal theory, he says, must be free from ethics, it must be free from politics, it must be free from sociology, it must be free from history, etc. But at the same time, he did not deny the value of all these branches of knowledge. He said that yes, these branches, ethics, political science, history, sociology, these are very important branches of knowledge. I don't deny law should be kept free from all these extra legal considerations. So he wanted only that law should be clear of all these other branches of knowledge.
These branches like politics, sociology, they are, he did not deny their value, but like in his theory, he kind of ignored it. He said that his theory is free from all these subjects. So he kind of contradicted his statement.
Not completely. See, he's not contradicting. He says that yes, these disciplines may be having its knowledge, but if we bring these branches into law, it will corrupt legal theory. He's saying that law has nothing to do with justice. How is it that you can bring other branches into it? That is the sole question. Now we'll discuss law as a normative science. We'll discuss law as a normative science. So Kelson described लॉ एज अ नॉर्मेटिव साइंस. जो नॉर्म्स होते हैं उसका ये साइंस है लॉ. उसका स्ट्रक्चर हम बाद में डिस्कस करेंगे. स्ट्रक्चर एक पिरामिड की तरह उसका होता है. That we'll discuss later on. He says that law is a normative science. It can be distinguished from natural science, which is natural science is based on causes and effects. Natural science is based on causes and what is its effect. जैसे कि law of gravitation. You know, there are causes of law of gravitation and there are effects of the law of gravitation. Now the law of natural science are capable of being accurately described. आप law of natural science को accurately describe कर सकते हो. It is capable of being accurately determined. तो natural science को आप accurately determine कर सकते हो. It can be accurately discovered in the form of ease. That means earth is round, है ना? So it can be accurately discovered in the form of ease. That is das sign. This is a German or Austrian word. Das, D-A-S sign, S-E-I-N, which is an essential characteristic of all natural sciences. When we come to science of law, he says science of law is a knowledge of what law ought to be. What law ought to be. That means das Sollen. D-A-S-S-O-L-E-N. Sorry, S-O-L-L-E-N. Das Sollen. D-A-S-S-O-L-L-E-N. Das Sollen. That is, it is a knowledge. Science of law is a knowledge of what law ought to be. अब ये ought proposition है ना, what law ought to be, ये नेचुरल लॉ की तरफ मत ले जाइए आप इसको. ये केल्सन का कॉन्सेप्ट थोड़ा डिफरेंट है बाकी चीजों से. सो साइंस ऑफ लॉ इज अ नॉलेज ऑफ व्हाट द लॉ ऑट टू बी. दैट मींस व्हाट द लॉ शुड बी. इट इज दैट ought character which provides normative character to law. Normative character. अब इसमें क्या है कि लॉ भी एक नॉर्म है, सैंक्शन भी एक नॉर्म है. ये बात याद रखिएगा. He gives an example of that. If A commits a theft, he ought to be punished, and that ought proposition is norm, right? If A commits a theft, he ought to be punished, and that ought character takes you towards the norm. Like Austin, Kelson also considers sanction as an essential element of law, but he prefers to call it an ought. He prefers to call it a norm. So याद रखिएगा, लॉ भी नॉर्म है और सैंक्शन भी क्या है, नॉर्म है. एंड सैंक्शन को बताने के लिए ही यूजेस ought preposition. सैंक्शन को एक्सप्लेन करने के लिए ही यूजेस ought preposition. Thus, according to Hans Kelson, law is primary norm which stipulates sanction. It is called positive law because it is concerned only with actual norm and not with ideal norms. Positive law is never concerned with ideal law. It is always concerned with actual laws, existing laws. ये तो आपको अभी तक समझ में आ गया होगा. That is why Dr. Allen, A-L-L-E-N, he was a jurist. He has described Kelsonite theory of law as a structural analysis as exact as possible. So this is a structural analysis of positive law as exact as possible. This is an analysis which is free from all ethical and political judgments or values. I give a pause here so that you should be able to ask a question if there is any. May I go forward? Now we come to sanction part of it. Sanction. Hans Kelson says that norm, that is sanction, मैंने आपको बताया था लॉ भी नॉर्म है और सैंक्शन भी नॉर्म है. So he says that norm, that is sanction, is a rule forbidding or prescribing certain behavior on the part of the people. Norm, which is sanction, is a rule which either forbids or prescribes certain behavior on the part of the people. जैसे हम कहते हैं ना, act or forbearances. So what sanction does? Sanction prescribes either act or forbearances. For Kelson, legal order is the hierarchy of norms. And having sanction, तो legal order, legal system कैसे बनता है? Hierarchy of norms से बनता है. Law की एक अपनी hierarchy होती है, he says. And the main part of it is sanction. And jurisprudence is the study of these norms which comprise the legal system, which comprise the legal order. He distinguishes moral norms with legal norms. So he says that there is a distinction between moral norms and legal norms. So he gives an example of that. Moral norm says that a person should not steal. Morality है ना कि हमें चोरी नहीं करनी चाहिए. हाँ, क्या आप बच्चों को सिखाओगे कि नहीं बेटा चोरी करना बड़ी अच्छी बात होती है? No. Moral norm is that a person should not steal. There are no sanctions to it so far. There are no punitive consequences to what we say that a person should not steal. And as long as there are no punitive sanctions, there are no punitive consequences, it is not a positive law. It is just a moral norm. It is just a moral law, ideal law. Since it has no sanction, it lacks legal force. So what we have to do is that we have to provide it a coercive force. Coercive force क्या होता है? Sanction होता है. आपके ऊपर एक चीज को थोप दिया जाता है कि नहीं आपको ऐसे फॉलो करना है. Now, if it is to be reduced, in the form of legal norm. अगर हमें इसको legal norm बनाना है, तो we will say if a person steals, he ought to be punished by the competent organ or competent authority or a competent state. If a person steals, he ought to be punished by competent organ or competent authority or by competent state. And that is how it becomes a law. Say for example, if a person commits a murder, he ought to be punished by the state or a court. That is how it becomes a law. This ought preposition in the legal norm refers to the sanction. And these sanctions to be applied for violation of law. Sanction कब apply होता है? Violation of law के time पे sanction apply होता है. Now we come to the next point, that is Grund norm. Grundnorm. Grund norm. Grundnorm is Grund norm. Grund norm is what? It is a basic norm. मैंने आपको थोड़ी देर पहले बताया था कि जो norms हैं, legal norms, वो हायरार्किकल ऑर्डर में होते हैं. आपने पिरामिड को देखा है क्या? पिरामिड्स को देखा है आपने या नहीं देखा? Have you all been sleeping or what?
No, sir. In real, we haven't. But we have studied in books and picture we have seen.
उसका पिक्चर तो देखा होगा यार.
Yes, sir. Picture देखा है.
वही तो मैं कह रहा हूँ. अभी आपको इजिप्ट में जाके पिरामिड थोड़ी ना देखना है. उधर तो वॉर चल रहा है. वो इजराइल पैलेस्टीन उधर वॉर चल रहा है ना इजिप्ट के बॉर्डर पे. वहाँ कहाँ से जाओगे? कैसा होता है पिरामिड बताइए? पिक्चर्स में देखा है ना आपने?
Triangular shape divided in layers,
whether it goes downwards to upwards or upwards to downwards.
upward to downward.
Upwards to downwards. हाँ? कैसे होता है बताइए?
Sir, downwards to upwards.
Downwards and upwards. So normative order भी वैसे ही होता है. It is like a pyramidal structure. Okay? It goes from downwards to upwards. मैं आपको थोड़ा सा इसको एक्सप्लेन करता हूँ कि जैसे सपोज यूनिवर्सिटी ने एक लॉ बनाया, कानून बनाया. सपोज दिल्ली यूनिवर्सिटी मेक्स अ लॉ फॉर एंटायर यूनिवर्सिटी. We have to follow that law. Why do we have to follow that law? Who has given power to Delhi University to make law? Who gave power to Delhi University to make law?
UGC?
मैडम पार्लियामेंट ना. लॉ बनाने की पावर यूजीसी कहाँ से दे देगा?
Yes, sir.
It is always a parliament which delegates power to other instrumentalities to make law, like executive. Okay. Now, why do we follow the parliamentary law? Delhi University के ऊपर parliament है. Why do we follow parliamentary laws? Who gave law making power to the parliament? किसने दिया?
So the constitution.
Constitution.
The system of our country.
So it goes from downwards to upwards. Above Delhi University there is a parliament, and above parliament there is a constitution. और constitution के आगे कुछ है क्या?
Sir, आगे नहीं है, but we as the people of the country.
But we cannot go that far also.
Yes, sir.
Huh?
Huh.
So it closes to the parliament because parliament is a basic norm, Grund norm, something that provides validity to all the laws. So let us discuss what is Grund norm, basic norm. Kelson's pure theory of law is based on pyramidal structure of hierarchy of norms. ये मैंने आपको बताया. And this entire legal structure, this entire structure of hierarchy of norms derive their validity from the basic norm, which is also known as Grund norm. And this term Grund norm has been coined by Kelson himself. Thus, Grund norm, which is also known as a basic norm, determines the content and gives validity to all other norms derived from the Grund norm. Grund norm का काम क्या है? It determines the content of the norms and providing validity to all other norms. And Kelson has no answer to the question as to where from the Grund norm or a basic norm derives its validity. कहता ये नहीं पता कि Grund norm की validity कहाँ से आती है. देखिए, हर norm को valid होना जरूरी है, ये तो आप मानते हैं. हाँ? तो फिर basic norm को भी valid होना जरूरी है. लेकिन how basic norm derives its validity, nobody knows. Kelson also does not have an answer to this question. He considers that a question of the validity of norm is a meta-legal question. It is an extra-legal question in which jurists need not intrude. कहता है ये एक्स्ट्रा लीगल क्वेश्चन है. I mean, grand norm is a consequence of extra legal factors. Like it is a consequence of political factors, economic factors, historical factors. It could be anything. So we need not go into the question of the validity of grand norm. On this point, Julius Stone, he's a jurist, he makes a comment that just as Austin's sovereign in a particular society is a mere starting point for legal theory, so also basic norm or a grand norm has to be accepted as hypothetical starting point or just a fiction which gives a legal system coherence and a systematic form. तो जैसे ऑस्टिन की थ्योरी में स्टार्टिंग पॉइंट क्या है? सॉवरेन है. तो बेसिक नॉर्म या ग्रैंड नॉर्म भी एक स्टार्टिंग पॉइंट है and it provides coherence to the legal system. While all norms derive their validity from the basic norm grand norm, the validity of the grand norm or a basic norm cannot be objectively tested. It cannot be objectively questioned. Instead, it has got to be presumed. It has got to be presupposed. आपको grand norm के validity को presuppose करना पड़ेगा, उसको प्रिज्यूम करना पड़ेगा, उस वैलिडिटी को आप क्वेश्चन नहीं कर सकते. You have to presuppose or you have to presume that it is valid by itself. Kelson, however, considers grand norm as a fiction rather than hypothesis. He says that it is not a hypothesis but it is a fiction. Kelson recognized that the grand norm need not be same in every legal system, but it has to be there. Grand norm need not be same in every state, but it must be necessarily there. सेम नहीं होगा ग्रैंड नॉर्म. जैसे हमारे यहाँ ग्रैंड नॉर्म कॉन्स्टिट्यूशन है. यूएसए में ग्रैंड नॉर्म कुछ भी हो सकता है. कॉन्स्टिट्यूशन हो सकता है, प्रेसिडेंशियल ऑर्डर्स हो सकते हैं, इंग्लैंड में क्राउन हो सकता है, नॉर्थ कोरिया में डिक्टेटर हो सकता है. सो इट कुड बी एनीथिंग इन एनी लीगल सिस्टम बट इट हैज टू बी देयर. सो ग्रैंड नॉर्म मे बी इन द फॉर्म ऑफ अ रिटन कॉन्स्टिट्यूशन और द विल ऑफ द डिक्टेटर. तो याद कीजिए, जॉन ऑस्टिन सेड दैट सोवरेनिटी लाइज either in a single person or body of individuals, either in an individual or a body of individuals. तो उसमें क्या है, वहां पे कॉन्स्टिट्यूशनल डेमोक्रेसी को उनके सोवरेनिटी के कॉन्सेप्ट में कोई प्लेस नहीं है, बट केल्सन के लीगल ऑर्डर में कॉन्स्टिट्यूशनल डेमोक्रेसी को पूरा स्थान दिया गया है. Here I stop again for a couple of minutes. Yes, absolutely, you are right. Constitution is a grand norm here in India. It can be presumed. Any other question? Hierarchy को समझते हैं, pyramidal structure को समझते हैं. Rohit, I am starting again. Okay. Let us try to understand pyramidal structure of norms. Kelson considers legal science as a pyramidal structure of norms, with grand norm, which is known as the basic norm, is at the top of the legal system, top of that normative order, and the subordinate norms are controlled by norms superior to them in hierarchical order. जैसे दिल्ली यूनिवर्सिटी के लॉ को कौन कंट्रोल करता है? पार्लियामेंट कंट्रोल करता है. और पार्लियामेंट्री लॉ को कौन कंट्रोल करता है? कॉन्स्टिट्यूशन कंट्रोल करता है. सो इन अ हायरार्किकल ऑर्डर, सुपीरियर नॉर्म कंट्रोल्स इंफीरियर नॉर्म्स. बेसिक नॉर्म, which is called grand norm, is however independent of all other norms because it is at the top. टॉप पे होने के कारण बेसिक नॉर्म इज इंडिपेंडेंट ऑफ ऑल अदर नॉर्म्स. आप हमारे कॉन्स्टिट्यूशन का एग्जांपल ले सकते हैं. कॉन्स्टिट्यूशन इज इंडिपेंडेंट फ्रॉम ऑल अदर लॉज, इजंट इट? प्रोसेस ऑफ वन नॉर्म डिराइविंग इट्स पावर फ्रॉम द नॉर्म इमीडिएटली सुपीरियर टू इट until it reaches at the top, at the grand norm or a basic norm, has been termed by Kelson as concretization of the legal order, concretization of the legal system. तो डाउनवर्ड से अपवर्ड्स जाने का जो प्रोसेस है, जो कि ग्रैंड नॉर्म पे खत्म होता है, फ्रॉम डाउनवर्ड्स टू अपवर्ड्स, यूनिवर्सिटी लॉ डिराइविंग इट्स वैलिडिटी फ्रॉम द पार्लियामेंट्री लॉ, parliamentary law deriving its validity from the constitution, and at constitution it closes down. This is known as concretization of the legal system, concretization of the legal order. Thus, the system of norms proceeds from downwards to upwards. And finally, it closes at the grand norm, which is known as the basic norm. Top पे आके grand norm पे आके ये close हो जाता है. The grand norm is taken for granted as a norm creating legal system or legal order. तो grand norm को taken for granted लेते हैं, उसकी validity को question नहीं करते हैं, because it creates a legal system or a legal order, and the creation of the legal order cannot be demonstrated, he says, scientifically, nor it is required to be validated by any other norm. ग्रैंड नॉर्म को वैलिडेट करने की जरूरत भी नहीं होती है और उसको डेमोन्स्ट्रेट भी नहीं किया जा सकता है साइंटिफिकली. He says, for example, a statute or a law is valid because it derives its legal authority or validity from the legislative body, that is parliament, and the legislative body in its own turn derives its authority or validity from a norm which is known as the constitution. ये example मैंने आपको already दिया है. As for the question from where does the constitution derive its validity, there is no answer of this question and therefore it is the grand norm. केल्सन की थ्योरी में कॉन्स्टिट्यूशन की वैलिडिटी कहां से है, इसका कोई आंसर नहीं है. In Kelson's view, the basic norm is the result of social, economic, political and other conditions. तो basic norm जो है social, economic, political conditions के कारण बनता है and it is supposed to be there. Grand norm is supposed to be valid by itself. The legal order as conceived by Kelson receives its unity from the fact that all manifold norms of which the legal system is composed can be traced back to the grand norm, which is a final source. So this final source is nothing but a grand norm, basic norm. तो जो पूरी लीगल वैलिडिटी किसी भी लीगल सिस्टम को मिलती है वो कहां से मिलती है? इट इज फाउंड फ्रॉम द बेसिक नॉर्म, ग्रैंड नॉर्म. तो ग्रैंड नॉर्म की डेफिनेशन भी लिख लीजिए. व्हाट इज ग्रैंड नॉर्म? ग्रैंड नॉर्म इज द पोस्टुलेटेड अल्टीमेट रूल अकॉर्डिंग टू विच नॉर्म ऑफ दिस ऑर्डर, ब्रैकेट में लिख दीजिए लीगल सिस्टम, आर एस्टैब्लिश्ड एंड अनल्ड, रिसीव और लूज देयर वैलिडिटी. इसको हायरार्की ऑफ नॉर्म्स को कंटिन्यू करें शाम में 9:30 पे.
ओके सर.
आप लोगों को समझ में आ रहा है ना ये वाला? We'll continue in the evening. केल्सन को कंप्लीट कर देंगे in the evening, right? At 9:30, same time.
दोस्तों, इस तरह के वीडियो को बनाने में काफी समय, मेहनत और रिसोर्सेस लगता है. आप अपना वैल्यूएबल फीडबैक जरूर शेयर करें ताकि एबनिशियो टीम को प्रोत्साहन मिले तथा आपके द्वारा दिए गए फीडबैक पर काम करके और इन्फॉर्मेटिव वीडियोस आप तक लाया जा सके. प्लीज लाइक द वीडियो, सब्सक्राइब द चैनल and share the video with needy one.
Good evening, sir. Yes, sir.
Good evening. Good evening. Have you been able to follow what we were doing in the morning today?
Yes, sir.
So law is a hierarchy of norm that we had discussed in the morning. In this lecture, I will continue this discussion. Law, according to Kelson, is a hierarchy of norm. It is a pyramidal structure. It is like a pyramidal structure. And on the top of it, there is something called basic norm, grand norm, which validates all other norms. And each norm validates the norm immediately inferior to it. So this entire structure, entire hierarchical order goes from the downwards to upwards. And it ultimately closes down at the top, at the basic norm called grand norm. And this is known as concretization of norms by Kelson. Kelson says that grand norm need not be same in every legal order, every legal system, but it necessarily has to be there. So that is his entire legal theory. Kelson characterized law as a technique of social organization. Law is what? It is a technique of social organization. It is not an end, but it is a specified means. As an apparatus of compilation to which there adheres no political or ethical value. So law has no political or ethical value. According to him, law is not an eternal sacred order, but it is a compromise of battling social forces. Law is a compromise of battling social forces. He's not saying that law is a class struggle kind of a thing. He's saying law is a compromise of battling social forces, and therefore the concept of law has no moral connotation whatsoever. Concept of law has no moral connotation whatsoever, क्योंकि ultimately law क्या है? It is a compromise of battling social forces. तो इसमें morality कहाँ से आ जाएगी? इसमें morality नहीं है. This is the view of Hans Kelson. As the necessary consequences of the extrajural or origin of the grand norm, the grand norm loses its applicability when a new government comes into power by overthrowing the existing government, either by revolution or by coup. So, grand norm also is not a stable kind of a thing. Grand norm can change. Since it is an extrajural hypothesis, it is an extra legal applicability of grand norm, that whenever the government changes, grand norm can also change. We have seen that in Pakistan. Sometimes military rule works there, sometimes constitution or civilian government works there. So grand norm keeps changing according to Kelson. Whenever new government comes into power, either by revolution or by military coup, grand norm can change. Sometimes when the grand norm changes, courts are confronted with the problem whether to continue applying the law of the overthrown regime, even though they are no longer effective, or to apply the laws introduced by the new revolutionary government which are lacking legitimacy. कौन से लॉ को अप्लाई करें, ये कोर्ट के पास एक क्वेश्चन होता है कि पुरानी गवर्नमेंट का जो कि ऑलरेडी ओवरथ्रो की जा चुकी है, जो अब इफेक्टिव नहीं है, उसको अप्लाई करें, या नई गवर्नमेंट के लॉज को अप्लाई करें जिसकी की लेजिटिमेसी नहीं है. There is no unanimous opinion of the judiciary on this point. However, it must be stated that this being a matter beyond the purview of jurisprudence, it has to be decided according to the political exigencies of the situation and general acceptance by the people. तो ये ऐसा क्वेश्चन है कि कौन से लॉ को अप्लाई करना है, ओवरथ्रोन गवर्नमेंट के लॉ को अप्लाई करना है या न्यू लॉ को अप्लाई करना है. इसमें जुडिशरी की ओर से कोई यूनानिमिटी नहीं है, यूनानिमस ओपिनियन नहीं है. एंड दैट इज व्हाई वी कैन अप्लाई व्हाटएवर लॉ इफेक्टिव. सो इट हैपेंस बिकॉज ऑफ द political exigencies of the situation or general acceptance by the people. Now, any question on this point here? Let us now discuss what are the implications of Hans Kelson's theory. Kelson's pure theory of law covers wide spectrum of legal concepts such as state. State जब law की बात करते हैं तो state की बात होती है. Sovereignty, when he talks about the grand norm, he also talks about sovereignty. कि जो पूरे लॉ को वैलिडिटी देता है, that is grand norm, and that is sovereign, although he does not use the word sovereign. Then he also talks about the private and public law. He also talks about legal personality, rights and duty. These concepts he talks about. According to Kelson, law and state are not different from each other. They are in fact one and the same thing. Similarly, he says there is no difference between public law and private law. Again, they are same thing. कोई difference नहीं है public law और private law में. Public law, private law एक ही चीज है. Kelson also denies any legal difference between natural person and juristic personality. Natural personality and juristic personality. Do you understand what is juristic personality or a legal personality? If anybody knows that, what is juristic personality? I'm asking first year students. What is juristic personality? What are you saying?
No sir, we don't have any idea. What is the difference?
You don't have any idea. See, please note down, this is a very important thing. Juristic personality is an artificial personality created by law against whom any person can file a suit, or that person can also file a suit against any person. That means that artificial personality or a juristic personality can be sued, or he can sue also, such as company. Company is an artificial personality. Hindu joint family, it is an artificial personality, legal personality or juristic personality. But Kelson denies the distinction between natural personality and juristic personality. Natural personality कौन है? The person who is a natural person, who is born on this planet. That is a natural person. For Kelson, all legal personality is artificial and derives its validity from the basic norm called ग्रंड नॉर्म. तो सभी लोग जो है आर्टिफिशियल पर्सनालिटी है. तो यहाँ पे कंपनी और नेचुरल पर्सन के बीच जो डिस्टिंक्शन है उसको केल्सन मानते नहीं है. ही सेड दैट ऑल द पर्सनालिटी आर आर्टिफिशियल पर्सनालिटी एंड दे डिराइव देयर वैलिडिटी फ्रॉम बेसिक नॉर्म ग्रंड नॉर्म. ही डज नॉट बिलीव इन द एग्जिस्टेंस ऑफ individuals' rights and he asserts that legal duties are the essence of law. कहता है कि किसी के इंडिविजुअल्स के कोई राइट होते नहीं है. Everybody has duties. In his opinion, legal rights is merely the duties if viewed by the person intended to require its fulfillment. तो rights कुछ नहीं होता है, जो भी होती है ड्यूटीज ही होती है. अगर आपके राइट है तो स्टेट की ड्यूटीज है, तो उसी तरह से सबकी कोई ना कोई ड्यूटीज होती है लॉ में राइट्स नहीं होते. दैट इज व्हाट इज अंडरस्टैंडिंग इट. नाउ बिफोर वी स्टार्ट क्रिटिसिज्म against Kelson's theory, can you tell me if you have any question? Because in the afternoon I did not take your questions. We talk about various rights like legal rights, fundamental rights, okay? But he says no, there are no legal rights or fundamental rights like that. There are only duties. There may be legal duties, there may be fundamental duties, right? So it is like that. So he recognized rights in the form of duties actually.
Okay, sir.
जिसको आप राइट कहते हो उसको वो ड्यूटीज कहते हैं. फ्रेंड्स, द क्रेडिट ऑफ इवॉल्विंग अ नॉर्मेटिव थ्योरी ऑफ लॉ goes to Hans Kelson. This theory seeks to differentiate actual law from natural law or existing law from natural law doctrines, and it also excludes justice, which was a very predominant characteristic feature of the laws introduced by fascist states and totalitarian governments. तो कहता है कि जस्टिस का लॉ से कोई लेना देना नहीं है, नेचुरल लॉ का एक्चुअल लॉ से कोई लेना देना नहीं है. सो दिस थ्योरी डाइवेस्ट नेचुरल लॉ फ्रॉम moral law. At the same time, Kelson's pure theory of law suffers from certain glaring defects, and those defects, those shortcomings or those lacunas we will be discussing here. The first problem is that this theory excludes all references of social facts, but at the same time this theory feels need of the society to implement the law. एक और आप कहते हैं कि लॉ में सोशल फैक्टर्स नहीं आने चाहिए, बट फिर आपको लॉ को इंप्लीमेंट करने के लिए क्या चाहिए? सोसाइटी चाहिए. एंड देयर दिस थ्योरी फॉल ऑन द ग्राउंड. Thus, his pure theory of law is without any sociological foundation. Second criticism. Kelson asserts that all the norms except basic norms, that is grand norm, are pure. सभी नॉर्म प्योर है लेकिन ग्रैंड नॉर्म प्योर नहीं है. Is it valid kind of an argument? This argument has no logic. This argument lacks logical basis. इसका कोई logical basis नहीं. We really fail to understand as to how subordinate norms which derive their authority, their validity from the basic norm, grand norm, can be pure when the grand norm itself is not pure. The norm itself is based on a hypothesis that it is an outcome of the combination of various social and political factors and other circumstances in a given situation. तो जब आपका बेसिक नॉर्म ग्रैंड नॉर्म ही प्योर नहीं है तो सब्सिक्वेंट नॉर्म्स प्योर कैसे हो सकते हैं? ये तो वही वाली बात हुई कि हमारे दादाजी नाजायज औलाद थे लेकिन हमारा ब्लड तो प्योर है. Commenting on this point, the jurist Julius Stone has sarcastically made a remark. He said that we are invited to forget the illegitimacy of the ancestors in admiration of the pure blood of the progeny. तो हमें ये कहा जाता है कि आप हमारे पूर्वजों के इम्प्योर ब्लड को भूल जाइए और हमारे प्योर ब्लड की तरफ देखिए, है ना? इट इज जस्ट लाइक सेइंग कि हमारे पूर्वज नाजायज औलाद थे, दे आर मिक्स ब्लड एंड वी आर प्योर ब्लड. तो ये एक इलॉजिकल टाइप का आर्गुमेंट है. वी शुड नॉट इवन go towards these types of argument. Now, third criticism, this pure theory of law is found to be based on a hypothetical consideration without any practicality. ये सिर्फ एक hypothetical theory लगती है, इसका practical basis कहीं पे पता नहीं चलता. It is not possible to divest law from the influence of political ideology and social needs of the people. अच्छा, कोई भी लॉ बनता है तो पॉलिटिकल आइडियोलॉजी से ही बनता है, ये बात तो आपको मालूम है. जैसे ट्रिपल तलाक को बैन किया, सुप्रीम कोर्ट का जजमेंट था, एक बात है, लेकिन ट्रिपल तलाक को बैन क्यों किया? क्योंकि पॉलिटिकल आइडियोलॉजी में था वो. 370 अबॉलिशन ऑफ 370 क्यों हुआ? पॉलिटिकल आइडियोलॉजी में था, है ना? तो लॉ इज अफेक्टेड बाय पॉलिटिकल आइडियोलॉजी. सोशल नीड्स को भी ध्यान में रखा जाता है while making law. So Kelson does not consider justice and morality as an essential attributes of law. तो ये भी एक बहुत बड़ा लैकुना है कि justice and morality are completely divested from law by saying that they are not important attributes of law. Next criticism, and this criticism is made by Friedman. Friedman says that Kelson's theory provides no solution of the conflicts which is arising out of ideological differences. कई जगह पे लॉ जो बनता है वो आइडियोलॉजिकल कॉन्फ्लिक्ट्स के बाद बनता है, और वो आइडियोलॉजिकल कॉन्फ्लिक्ट का कई बार आउटकम भी होता है. तो दिस थ्योरी, Kelson's theory, Friedman says that this theory rejects the element of justice as a mere emotion, which is really not true. क्या जस्टिस सिर्फ एक इमोशनल एलिमेंट है लॉ में? क्या जस्टिस का रोल भी होता है? All of us know that justice has a very important role to play in law. Law cannot be completely devoid of morality. Law cannot be completely devoid from ethics. Because ethics and morality, justice, this gives law an honorable place in the society. हम लोग कोर्ट क्यों जाते हैं? इसलिए क्या कि लॉ और जस्टिस का कोई आपस में मेल है ही नहीं, तालमेल है ही नहीं. हम कोर्ट में क्यों जाते हैं? बिकॉज हम ये मानते हैं, वी बिलीव दैट जस्टिस विल बी डन इन अ कोर्ट ऑफ लॉ, राइट? जस्टिस इज अ थिंग दैट प्रोवाइड्स ऑनरेबल प्लेस टू लॉ इन द सोसाइटी. यहाँ पे मैंने 3-4 क्रिटिसिज्म्स आपको बता दी. इफ यू हैव एनी क्वेश्चन यू कैन आस्क मी and I'll move forward. Any question? Sorry. Kelson's account of legal dynamics is inadequate. This theory ignores the purposes of law. Law के purposes होते हैं, बिना purpose के law बनता नहीं है. For example, while considering the validity of a law, while considering the validity of particular enactment, the courts really takes into account the prevailing custom or the motives of the legislature while making law, and they try to correlate it with the social purposes which the act seeks to achieve. तो क्या customs हैं, लोगों के क्या needs हैं, law के purposes क्या है, ये court जरूर देखता है when court tries to test the validity of law. Let's just take into consideration the competing interest which may not necessarily be purely of a legal nature. Next criticism is that Kelson's pure theory of law also suffers from methodological defects, methodological shortcomings. This theory ignores the fact that the action of the authority which enforce law, if these actions of the authority has to be valid, also has to be in accordance with the procedure established by law, and therefore it becomes necessary to probe into the content of it. जब भी authority कोई action लेती है, coercive action, वो कोर्सिव एक्शन प्रोसीजर के अकॉर्डिंग होना चाहिए. अगर वो प्रोसीजर के अकॉर्डिंग नहीं हुआ देन वो वैलिड है ही नहीं. तो यहाँ पे प्रोसीजर की बात ही नहीं की कहीं पे भी केल्सन ने. तो दिस इज अ मेथोडोलॉजिकल डिफेक्ट. ये मेथड ही सही नहीं है, एनालिटिकल मेथड. फिर मेयर यूज ऑफ फोर्स वुड नॉट वैलिडेट अ लॉ. तो आप किसी के भी अगेंस्ट कोई भी फोर्सफुल एक्शन ले लो विदाउट फॉलोइंग ए प्रोसीजर, उसका क्या यूज है? कोई यूज नहीं. केल्सन्स नॉर्मेटिव सिस्टम इज वन साइडेड. दिस remains indifferent to the content of norms, content of law. Next criticism. Kelson argues that Grundnorm imparts validity as long as the total legal order remains effective. ये भी सही नहीं है कि Grundnorm तब तक ही वैलिडिटी देगा जब तक लीगल सिस्टम इफेक्टिव रहेगा और रेफरेंडम तो चेंज भी हो सकता है। तो ये बिल्कुल इनवैलिड टाइप ऑफ आर्गुमेंट है। This argument does not hold good when judiciary of a state refuses to accept the legality of a usurper who assumed power by force and is deposed sooner or later because of his legal order cannot be said to be effective। तो ऐसा कई बार होता है कि किसी ने पावर को अज्यूम कर लिया है गवर्नमेंट को ओवरथ्रो करके, लेकिन गवर्नमेंट जुडिशरी ने उसको रीस्टैब्लिश कर दिया बिकॉज दे आर द पावर यूजरपर्स। ऐसा एक बार हुआ था पाकिस्तान में, मुझे याद है 1991 में गुलाम इसाक खान वाज अ प्रेसिडेंट एट दैट टाइम एंड सुप्रीम कोर्ट सेड दैट नो, गुलाम इसाक खान वाज wrongfully refused his powers। Thus, there was a case, Jilani versus government of Pakistan, government of Punjab in Pakistan। This was an old case though, 1950s का केस है ये। The Supreme Court of Pakistan in this case declared the usurper of a state power as illegal because they were unlawful ab initio, notwithstanding effectiveness। यहाँ पे सुप्रीम कोर्ट ने डिक्लेयर किया जिलानी वर्सेस स्टेट ऑफ पंजाब में कि आपने जो लीगल ऑर्डर यहाँ पे क्रिएट किया है वो इफेक्टिव होने के बावजूद भी अनलॉफुल एब इनिशियो है। राइट सिंस द बिगिनिंग इट इज अनलॉफुल, इलीगल। दिस डिसीजन मेक्स इट एम्पली क्लियर दैट केल्सन ड्रू नो डिस्टिंक्शन between effectiveness of a legal order which subjects are compelled to obey due to fear or force of the usurper of state and effectiveness of a democratically accepted ruler whose legal order then willingly obeyed by the people। Thus, it would be seen that Kelson's theory does not apply to revolutionary situation where someone assumes dictatorial power by usurpation। So these are the criticisms against Hans Kelson's theory, but despite these shortcomings, this theory has tried to make a legal order. It has tried to demonstrate a legal order by analysis। So we have completed Kelson. In 5 minutes time, we will start historical school of jurisprudence। If you have any question, you can ask me right now।
दोस्तों, इस तरह के वीडियो को बनाने में काफी समय, मेहनत और रिसोर्सेस लगता है। आप अपना वैल्यूएबल फीडबैक जरूर शेयर करें ताकि एबनीशियो टीम को प्रोत्साहन मिले तथा आपके द्वारा दिए गए फीडबैक पर काम करके और इन्फॉर्मेटिव वीडियोस आप तक लाया जा सके। यदि आपको यह वीडियो पसंद आया हो तो प्लीज लाइक द वीडियो, सब्सक्राइब द चैनल and share the video with needy one। Thank you for watching videos। Thanks a lot।